Okay, Mr. Lyman, good morning, sir. I see you. And Mr. Bartlett, good morning, sir. I see both of you. Excellent. All right, Mr. Lyman, you've unmuted. Excellent. You're ready to proceed. You've got 20 minutes. How much time do you need for rebuttal, sir?
I'd like to reserve 5 minutes, Your Honor.
Very good. And whenever you're ready, please proceed.
Thank you. May it please the court, my name is Chance Lyman. I represent the appellant, Dean Wish, in this case. At its core, this case is about a property owner effectively losing his retirement nest egg when Lee County, prompted by an outside organization, unfairly devalued the investment property by radically reducing the residential density. Now, fortunately, the Florida legislature has created a remedy for precisely this scenario. The Burt Harris Private Property Rights Protection Act provides for compensation when private property rights have been unfairly affected by the government. The act provides that it was created to provide greater access to relief than that was available under the common law. This case comes to your honors on a summary judgment and presents two issues under the act, both of which this court reviews de novo. The first issue presents a question that no Florida appellate court has directly addressed: whether a plaintiff can maintain a Burt Harris claim where he owned the property when the unfair burden was applied, but was forced to sell the property prior to the conclusion of the case.
Let's focus on that, Mr. Lyman, if we can. If you look at the actual language of the act, it does very clearly say property owner, and you would agree that your client is no longer a property owner. Can we agree to that?
I would agree to that, subject to the position that my client retained relevant title under the deed, the corrective deed, and the sales contract.
Okay, so how do we then, because this, I think you've indicated this will be a case of first impression for us. Is that correct? There's really no cases that say, oh, you have this property, you sell it, you're maintaining certain things that you could proceed. There's really no case law supporting your position.
Yes, Your Honor, nothing directly on point.
Okay, so how do you, I guess, what is your best argument that he should proceed under the act?
The plain language of the act, pure and simple. This is just a question of statutory interpretation. Our position is based entirely on unambiguous plain language of the act.
But it isn't really unambiguous, is it? Because you've got the word when, and I know you're hanging your hat on the when meaning meaning at the time that your client was a property owner, whether they still are or whether they are not. But that kind of seems to me in conflict with the other part of the statute that says you have to be a property owner.
Well, I believe the other part of the statute that you're referring to is just the definition of the term property owner. So under a plain language review, you still have to insert a definition into the substantive provision of the act because you have to read the act in harmony as a whole. So you can't read a definition section divorced from the substantive section to conduct the plain language review. And subsection 2 starts with the word when, which we argue creates the temporal component of the statute, because subsection 2 is the one provision that actually creates the entire right to relief that the rest of the statute is describing how to operate. So when a specific action of the governmental entity has inordinately burdened real property, the property owner of that real property is entitled to relief. And that's the groundwork. That's the plain language that provides that the trial court erred in determining that selling a property mid-suit somehow takes Dean Wish out of that right to relief. And for example, if you insert the property owner definition, just insert it into that substantive provision, here's how it reads. When a specific action of a governmental entity has inordinately burdened real property, the property owner of that real property, insert, which means the person who holds legal title to the real property that is the subject of and directly impacted by the action of the governmental entity, and insert, is entitled to relief. Period.
Who holds? It doesn't say who did hold, who in the past held, who holds.
It says who holds, but again, that use of the present tense holds has to be inserted into the substantive provision, which starts with the word when and states when exactly the burden is analyzed, when exactly the property owner is analyzed, when exactly that tense is analyzed. So the use of
this is one of the few cases that has sent me scurrying to Scalia and Garna, and you talk about present tense, but there seems to be something to this notion of a present indefinite tense.
Well, yes, Your Honor, that's certainly true, the present indefinite tense. I'll first note that this court has stated in Pfeiffer v. City of Tampa that tense is not dispositive on plain language statutory interpretation questions, because you still have to read the statute as a whole and in order to divine the legislature's intent, because again, pole star of intent is plain language. So that's what this court is looking for. And
do I need to take into account, however, that should I view it in a limited context, given that I'm expanding the exposure of a public entity?
So I believe the answer to that is no, because the plain language is under our position is unambiguous. So what you just referenced, I believe, would fall more in the camp of a construction of the statute. So you'd have to decide that the language is actually ambiguous in order to get there. So before moving all the way to construction, I mean, I'll note that we would argue that there is no strict construction that applies to this statute because it's remedial. But I just want to reiterate that if it's unambiguous, which we contend it is, and certainly the county and the trial court didn't identify any ambiguity before proceeding to a strict construction. If it's unambiguous, you don't need to consider the expansion or not of a remedy, because it's unambiguously saying the remedy is created in subsection 2. When the action is imposed on the property owner who holds legal title is entitled to relief. And that same temporal component, the is actually contained in the definition of property owner itself, because that definition asks, I'm reading from the definition, the term property owner means the person who holds legal title to the real property that is the subject of and directly impacted by an action of a governmental entity. That's the same temporal component that's in subsection 2 with the when and the is that's in that subsection. So that's unambiguous. And to the extent that, I would also note that the county's request for attorney fees and request for attorney fees in this appeal too is entirely still premised on Dean Wish still falling in the definition of property owner at this time, because they're seeking attorney fees from Dean Wish. So that in itself is paradoxical in the county's argument. But if we have to proceed, if this court sees an ambiguity when the definition is inserted into the substantive provision, then the ambiguity has to be construed in favor of Dean Wish, because the act is remedial. Now, remedial acts, whether you call it liberal or something else, remedial acts have to be construed in favor of granting access to the remedy created. The remedy created is explicitly in subsection 2, when the government burdens property, the owner is entitled to relief. That's Dean Wish here. And if you see an ambiguity in that phrase with the use of just the present tense in the definition section, then it's still Dean Wish, because you have to construe it as a remedial act in favor of granting Dean Wish access to the remedy. And Dean Wish isn't trying to
I wanted to ask you something you said earlier that relates to this. When he sold the property, he really didn't retain any title to anything, right? He sort of reserved for himself a chosen action, but he maintained no property right. Is that correct?
Well, to the extent property rights are, bundles of twigs that are associated when you transmit property over title, his corrective deed explicitly notes the right to reserve what's going on in this case right now. So from a perspective
which is the chosen action.
Yes. And frankly, that's the result that would result under the common law. That's entirely consistent with the situation that happens in the common law, which is evidenced by this court's Canny decision. When you have an injury to your land, when you own that land, that injury stays with you. It doesn't go with the land. And this court's Canny opinion explicitly note that the only way it could actually move with the subsequent owner is actually the inverse of what happened here. If the deed, and this court stated that in the deed, if the right to maintain compensation moved to the next owner via the deed, then we'd have a different story here. So under the common law, if Dean Wish did nothing, he still has the right to compensation. But he actually went.
And I guess, Mr. Lemon, I follow up on what Judge LaRose said, and that I'm glad you answered the question, because my review of the record, when he sold the property, he did not retain any right to title of that property. I realize you're arguing about he was making a claim for damages and so forth, but with respect to the title itself, you'd agree that he sold it to the third party.
Absolutely. He sold it to the third party who took it as is, paid a diminished price for it based on, the government burden that was actually already imposed on it. And he made it crystal clear. I mean, that's in affidavits, certainly in the sales contract, certainly in the operative deed. It's all crystal clear that the rights here are maintained. So whether, the question is some ambiguity in what it means to hold legal title, the answer is really that the rights, whatever those rights are, were certainly unambiguously held by my client after selling the property. And so those, altogether, again, if we're going to see an ambiguity in this statute, construing it remedially, we get to consider, the fact that the common law result would be such that Dean Wish is still entitled to continue the claim. That's what happens as this court stated in Canny. And, a statute that creates modifies the common law to make it more expansive than was already available under the common law can't be construed as creating something that's more restrictive than the common law. That was recognized expressly by the 4th DCA in the Rousseau case, where they reviewed the statute, didn't see an obvious statute of limitations, and expressly noted that it's unreasonable based on the legislative intent, the legislative history, the words of the drafters. It's unreasonable to construe a greater restriction than that was available under the common law, when the very first subsection of the statute and its title state that it was specifically enacted because owners were having too much trouble making takings claims. So the common law is essentially a baseline that Dean Wish is entitled to the benefit of under a construction of the statute based on any ambiguity. And a remedial construction is absolutely the one to apply here, because we're talking about access to a remedy, not expansion of a remedy. Dean Wish unquestionably had access to the remedy when he filed the suit, when he perfected the pre-suit procedure, and when the government burden was applied. And under the county's view, the trial court's view, now they're saying, despite the fact that he's the only one who suffered the burden, no one else suffered that burden. He's the only one who perfected this pre-suit procedure. He's the only one who filed suit, and he's the one who litigated the case for years. Now, all of a sudden, there's a new aspect to the statute that doesn't exist anywhere in the statute, mind you. There's no provision in the statute that says you have to maintain ownership throughout the conclusion of the case. That's added language. In fact, the trial court added the language current when in its order by saying you have to be a current title holder to seek relief under the act. That's not in the statute. So that's a rewrite, an impermissible rewrite. But the point
Mr.
is,
Lyman, could you tell me why alternatively we couldn't rely on our Turcali case and the challenge to his appraisal?
The appraisal, absolutely, yes. Well, the Turcali case is just patently distinguishable, and it's a huge fact here. Turcali is addressing an appraisal based on property that the claimant, that the plaintiff does not own. That is the dividing line. That's the dividing line in essentially all of these other Burt Harris Act cases, which there aren't very many of, but cases like Vail, cases like the Supreme Court's Hardy decision, the first DCA Smith decision, those are all in the camp of one big distinguishing factor. Whether you are seeking compensation for something that happened to your property or something that happened to your neighbor's property. So Turcali—
Don't you have to take into account the extent of the property, whoever owns it, the extent to which the property was affected by the ordinance?
Absolutely. You do have to take that into account. And that's exactly what the Dean Wish appraisal does, the pre-suit appraisal. It doesn't talk about anybody else's property. It talks specifically about Dean Wish's land. It says there was a density reduction that was applied to this land, specifically to about 85% of it. It It was the rural transition to suburban rural, or coastal rural, excuse me, that resulted in, effectively a 90% density reduction. That's expressly stated in the appraisal. And I'd point out to Your Honor that the Turkali decision, this court clarified that to the extent it sees an appraisal as defective, the problem with a defective appraisal is about giving the government the ability to understand what's at stake, what the liability, the potential liability of the claim is. This court stated in Turkali that if you have an appraisal based on property you don't own, the government can't properly evaluate the factors that it needs to evaluate when it makes its statutorily required settlement demand.
Can the government make that analysis if the appraisal includes property that is not affected by the ordinance?
In this specific scenario, yes, because the appraisal makes it very clear that the only government action that's relevant here is a density reduction. It's only relevant to the fact that there was a plan to put 336 units on the land. The only reason that 336 units on the land couldn't happen is because of coastal rural designations, which resulted in less units to some of the land, which is a loss of about 100 units. And when you put that together, it's basically just a math problem at that point. The county can absolutely evaluate what's left, potential liability of the claim. The appraiser set out all the terms that the appraiser was using, and basically did a point A and point B. Point A is—
Can I interrupt, Mr. Ron? You're going into your rebuttal time right now, but feel free to respond to the question.
I'll just respond. So I just want to point out that the appraisal is essentially a mathematic computation. Point A is with the density that Dean Wish used to have, and point B is without that density. The issues that are going to designations that weren't affected, those are constants. That in mentioning them in the appraisal doesn't void the appraisal. Those are constants. It's not a problem for the government to figure out what's at stake here. And I'll reserve the remainder of my time for rebuttal.
Very good. And you have about 4 minutes, Mr. Lyman, okay? Very good. Excellent. All right, Mr. Bartlett, excellent. You've unmuted, so you're ready to proceed. All right, sir.
Thank you. I'll start right there. Turkali is not about including your neighbor's property. It doesn't matter whose property is added. It's whether all of the real property, as defined in the Act, is and only is evaluated by an appraisal. The other cases he also cites are also cases in which the claim was made, and to the extent there was an appraisal was based upon property, real property, that was not affected by the law, rule, or regulation at issue. That is exactly the case here.
Mr. Lyman is suggesting that the appraisal carves out the unaffected property. So what's your answer to that?
It does not. The property was totally used. There is a site plan that was filed. It is actually part of our brief. It may be kind of light, given the colors overlying it, which show the comprehensive plan overlays on it. But there is absolutely no way, and in fact, the only evidence before the court was that there is no way to extract, if you will, the coastal rural property from the outlying suburban and the wetlands property that was also included in the appraisal. It's simply not possible. There's an affidavit from Charles Haynes, who's an expert appraiser, as part of the record, which points that out. But you really don't even need to go there, because during the case, when we would have had an opportunity to depose, to ask the appraiser that question, which frankly, I don't believe he could answer as easily as Mr. Lyman, but he was delisted. the so-called appraisal that was filed as part of the claim is at best hearsay. There is no way, there is no one to authenticate that document. There is no one to explain how the document allocated values or didn't allocate values. It is not a bona fide valid appraisal, which is the requirement of the statute. So lawyers can argue all they want about, you can allocate dollars here, you can allocate dollars there. That doesn't do you any good, because as we sit, as the trial court sat in that summary judgment hearing, that document is meaningless. It could have satisfied an argument that they filed a document entitled appraisal with their claim, but not any more than that. Even in their brief, they say it doesn't stand for the truth asserted therein. It doesn't. So whatever numbers, whatever math might have been used, those are not part of this record. And the trial court at summary judgment had no material facts in dispute with respect to that document. In fact, there's an appraisal from an affidavit from our appraisal that cites two separate errors. One of them is the bundling argument that we've already just discussed, the totality problem. We included, or the claimant included, property that wasn't directly affected by the law, rule, or regulations as required under the definition of real property. The other problem is when we go to the circuit court's job at the determination of liability, which is where we were sitting. All discovery had been done, and we were sitting at a point where liability was about to be tried. And subsection 6A of the Act says the circuit court shall determine whether an existing use of real property existed. All right, that's the first thing that the trial court's supposed to do at a liability trial. And you say, well, what's an existing use? It's defined under the Act in subsection 3B. And I'll skip down to subsection 2, and it's land uses which have created an existing fair market value in the property greater than the fair market value of the actual present use on the property. Well, ostensibly, Dean Wish argued that there was a residential value that was in excess of the actual agricultural use. All right, that was their claim. However, without an appraisal, which obviously is hearsay, you can't look at it, it doesn't say anything. And based upon the affidavit of Charles Haynes, there is no, because Mr. Haynes actually appraised the property, he was deposed. He filed an affidavit to which there was no response. And that affidavit said, based upon my opinion of valuing the property with and without the regulation at issue, there is zero damages. There's none. So as we were going to determine at that liability trial whether there was an existing use of real property, the only evidence before the court was the affidavit of the Lee County's appraiser that says there is no existing use because there is no change in the fair market value with or without the complained upon of regulation. So,
Mr. Bartlett, let me ask you a question that was raised in the briefs, and it's something that I think is a legitimate concern. To interpret the Act the way that you are suggesting, potentially lends itself to abuses by an unscrupulous party who decides that they're just going to drag things out and outspend the other side, if in fact the claimant has to maintain property ownership all the way until the end of the process.
You want
I'm
me to,
concerned about that. How would you respond to that?
Your Honor,
Because it
this,
seems like if an entity, the property is burdened by some governmental action, and there's no particular end date or end game involved, what is the incentive for the municipal entity to work towards a resolution?
well, in my experience litigating a number of these, I haven't seen any reluctance of the government to do that. This statute, however, is set out with a set of steps that are required to go through that necessarily take a long time. Okay, this isn't extra. This is not constitutionally required. This is a new cause of action, self-contained statute that's different from the constitutional law. And the legislature decided, for some reason, I don't know why, but they decided that this thing is going to take a while. They provided for notice and response that takes upwards of a year. They then, because they didn't give a statute of limitations running, they didn't give the landowner 4 years to file a lawsuit. The parties proceed to a liability only trial. There's 2 trials required in this proceeding. At the conclusion of that, if the government loses, the government gets an interlocutory appeal. Once the interlocutory appeal is decided, you come back to the trial court for a jury trial on damages. It, as a necessity, it's going to take years.
And perhaps, Mr. Bartlett, because of that very reason, why shouldn't Mr. Lyman's interpretation of the statute that says when, that basically that's all that you need to do, is that the plaintiff need only own the property when, and that's the operative term, when the government imposes the burden, primarily because it's going to take several years.
The structure of this statute is such, and the language of the statute is such, that that over application of one word, when, requires you to revise the entire act. Okay, the act, first of all, says at the end of this, if you go through the entire process and the government pays money, then the government gets for that money the property rights it burdened, right? And it goes on further and says the government can sell those property rights if they want.
I'm just concerned that this Byrd-Harris Act provides relief, but it provides it actually provides an incentive for the government to act aggressively and delay and take their time about resolution, because not every party can afford to hang in there long enough to acquire the fruit of the process. I think that you laying out the timeline is supporting what I'm trying to suggest, is that's my concern, is that, like in this instance, for example, if you have to be a property owner till the end, and these folks, apparently one of them was elderly and they were running out of money and they just couldn't fight the fight any longer. So then it just becomes even if there is a right, even if there is a provable right, it's a right without a remedy.
That's the way the statute is written, Your Honor. The statute actually.
But Mr. Bartlett, then I have a situation that the owner or the past owner has no remedy. The new owner takes the property as is, so it has no remedy. So I'm trying to figure out who checks the government's power.
Well, first of all, if the new owner has no remedy, then Dean Wish has no remedy either. Okay. Dean Wish came into this property 7 years after the regulation they're complained about came into effect. Okay. When they bought the property, it was 1 unit per 10 acres. I would argue that Bokeelia Growers, the new owner, has exactly the same rights as Dean Wish did. So if they want to make their application and actually get denied, which Dean Wish never did get denied, they filed a defective application. But if Bokeelia Growers goes through the process and for some reason gets denied, they would have the right to bring a bird parasite claim if they want.
But now Dean Wish has unloaded the property at a discount because of the change, and they're just out of luck. The new owner has the remedy and Dean Wish has nothing except a reduced value for the real estate.
I don't believe that there's any discounting here, Your Honor. The facts are undisputed that to the extent there has been a change in the number of residential units that are applicable to this property, they have actually been increased, not decreased. The decrease that Dean Wish has complained about shows up only in their complaint. Their expert land planner testified that there's actually been an increase of 95 residential units applicable to this property. Okay, there is no damage here. This is a complete snow job with respect to what was brought here. Their only issue in their complaint was a loss of residential units. During the time that the application was pending, the county was in the process of increasing the density for the very property we're talking about. Not only their property, but all coastal rural property in Pine Island.
And you counsel, you may be right about that, but that doesn't change the notion that the claimant should have an opportunity to make its case. If we agree with your interpretation of the statute, we never even get that far because they're not the property owner.
But that's what the legislature said they needed to be.
Okay. I just wondered if you had any more to offer than that.
That this statute is one that encourages settlement between the landowner and the government. These cases arise because of an unpopular development option, okay? Where the government doesn't want to grant the landowner whatever development rights it's seeking. And as a result, the claim made to the government through the Barrett-Harris Act allows the parties to come to an agreement with respect to development of the property. And that development of the property, this statute even provides for development in situations where it would violate statutes and other rules and regulations. And the Act creates a procedure for doing that. So there is, I mean, believe me, a multi-million-dollar claim from a landowner does spur the government to action. In most cases are resolved that way. So it's only when you want the prize, in other words, only the dollars, not the development rights, that you get to the situation you're describing. And if you're serious about developing your property, you would want your development rights, and that's where most cases go. This is an odd case where neither the facts nor the law support the landowner. Frankly, the appraisal issue, the failure to support their own appraisal, kills this case without even getting to whether you need to hold title or not.
Mr. Bartlett, I know you just have a couple of minutes left. You said something, and perhaps I did not hear you correctly. I think you indicated that the appellant bought the property after the density was in place. Did I hear that wrong?
Yes, Your Honor, that's correct. The density on Pine Island was reduced to 1 unit per 10 acres in 2003.
Okay.
Dean Wish was organized and acquired the property in 2010. There has been an argument that Mr. Ed Dean controlled all of these entities back before 2003. But that's a reverse piercing of corporate veils in order to get that. He may have had interest in some of those entities, but as was set out in the summary judgment order itself, the court laid out a derangement of title to the various 55 parcels and showed the way title was transferred. In any event, the partners in Dean Wish are Ed Dean and Gary Wisnowski. They are equal partners. It's not Ed Dean. They both filed affidavits in this case, by the way. And you simply cannot pierce the corporate veil yourself for your own benefit.
And I'm looking at here. So basically, Dean Wish, the corporation itself, was formed in 2010. And that corporation, and you've indicated that it was holding approximately the 55 continuous parcels. I see that here. So because they're the ones that are seeking this action, and because the actual change in density took place in 2003, as I hear your argument saying that they formed this after the change of density took place.
That's correct. They took title with the density being 1 unit per 10 acres.
Okay. All right. Thank you, Mr. Brown. I just want to clarify that. And actually, with that, sir, you've reached close to your 20 minutes. Are you okay to stop, or I'll give you a few minutes just to wrap it up? You're good?
I think I'm fine, Your Honor. Thank you.
Very good. Thank you, Mr. Bartlett. I'm going to ask you to, excellent. Mr. Lyman, help me out with this, because I want to just put, whoops, there's the timer. All right. Mr. Lyman, okay. Dean Wish formed the corporation that included all of that in 2010. The actual change in density took place in 2003. Why isn't Mr. Bartlett's position about, hey, you guys, your client actually is trying to say that he's property owner, but actually became property owner after that change in density?
So a few reasons. The first one I'll say is that's not really before this court. That's not really an issue properly presented in this appeal. The trial court, the predecessor and the successor judge rejected that argument. And the county didn't cross appeal that ruling. And the second thing is, this is an as applied statute. So when Dean Wish is holding the title in 2010 and perfects the pre-suit procedure and makes the request for administrative increase, that's when when the burden is finally applied. There's actually the Cofield case. The first district's Cofield case is very relevant here. Now, the first district basically rejected the argument that opposing counsel just made, where moving title to the property in and out of legal entities isn't something that affects the definition of property owner under the statute. Now, admittedly, the first DCA sort of assumed that and didn't decide it, but that's persuasive here. And that's exactly what Dean Wish did. And I'd also like to point out that Dean, a previous entity, which was still Edward Dean's entity, attempted to bring the same Bert Harris claim, actually, that's at issue here, in 2006 or 7, and it got dismissed based on the county's argument that the burden hadn't been imposed yet. So it's another thing that really goes back to what Judge LaRose and Judge Black were saying about sort of the parade of horribles. If no one's allowed to recover for the unfair burden that was applied to this property, that's a windfall for the government. How could the legislature have created a Private Property Rights Protection Act that doesn't protect private property rights? So
Mr. Lyman, that's the law, and this law has been in existence for how long? Right?
1995.
Yeah. And so,
But it was,
but you think at this point, if we go through that route, that case law should have come up by now saying, you know, this is an encroachment, this is too much, the government could really take advantage. So that's one of the things, shouldn't we look at as well? Because that the Burt Harris Act has been in place for a long, long time.
absolutely, Your Honor, but it's sort of interesting that the discrete case law that arises in Burt Harris law is always sort of about a very discrete provision of the act under a very specific set of factual circumstances. So, you know, whether it's because a lot of Burt Harris claims settle or whether it's because they just don't get appealed, I mean, I'm not sure that that necessarily changes the analysis of what a plain language review means. And I would also say that the remedy available under the statute, it is remedial. It was created because takings law was too tough, basically. So the legislature explicitly wanted to make a property owner who's suffering a very similar sort of burden that the property owner would suffer under common law, and make it easier to get access, actually compensation under the remedy. This doesn't have to do with sort of the title rights and things like that. This is about pure and simple compensation. And the reason that the when interpretation, which I don't think I heard a direct response to why that's not plain language, meaning that the plaintiff only has to hold it at that operative time. That's the legislature defining the cause of action. And it said, is that my time, Your Honor?
Yeah, that's your time. Sorry, I'm using my iPhone to have the timer, Mr. Lyman. So since we're working remotely, I don't have the courtroom clock here. All right.
Absolutely, Your Honor.
Yeah, well, no, why don't you wrap it up, Mr. Lyman, okay?
Well, yeah, I would just like to say, the parade of horribles that Judge LaRose and Judge Black identified is exactly what's going on here. And this court should not allow that to happen. And to the extent this court disagrees, we do ask that the court certify our questions of great public importance to the Florida Supreme Court to resolve these issues. Thank you very much.
Thank you, Mr. Lyman. Thank you, Mr. Bartlett. It's a very, very interesting issue and really well argued on both sides. I want to thank you both, okay? Wonderful. What we're going to do right now, I think the court's going to be taking a 15-minute recess, and then we'll be calling the next cases. Thank you all.